Hello friends, welcome again. Look at a report of Times of India of April 2024. Supreme Court formed a 9 judges bench to interpret the Article 39 subclause B. Supreme Court bench can be of 3, 5 and 7 judges also. What is 9 judges bench? This is actually called the constitutional bench. Why repeated asking for forming 9 judges bench to interpret Article 39 subclause B, which ultimately followed by Supreme Court? Let's look at its constitutional background and past history of cases it faced off. Article 39 subclause B comes under Directive Principle of State Policy DPSP, an enshrined socialistic principle. In gist, Article 39 subclause B defends the concentration of material wealth and resources and advocates its fair distribution in community. But India is not an authoritarian state. It is a democratic state and also have fundamental rights for its citizens. Then how to implement such a DPSP in India in policy making? But it implemented in various acts in past like Minimum Wages Act 1948, Tenancy Reforms Act, Labor Regulation Act, Equal Remuneration Act 1976. Then how it got implemented? Wait, Indian legislative made a defense system to keep Article 39 subclause B validation alive. Like 1. Addition of Article 31C by 25th Amendment Act 1971. It is the same amendment by which right to property curtailed from fundamental right. Now, Article 31C tells that no law that is inconsistent with Article 14 and Article 19 but seeks to implement socialistic directive principles contained in Article 39 subclause B and Article 39 subclause C shall be void and could not be questioned in any court of law. This amendment came just aftermath of Goloknath case 1967, which gave verdict as fundamental right is sacrosanct and cannot be amended by Parliament. Number 2. 44th Amendment Act 1978, which terminated Article 19 subclause 1 F and Article 31 right to property. Further, in Keshavananda Bharati case 1973, which upheld validity of Article 31C but made it clear that Article 31C will come to subject to judicial review. Now, we study it case to case basis. Number 1. State of Karnataka versus C. Ranganathan Reddy 1977, which opined that private owned resources will not fall within ambit of material resources of community. Here a 5 judges bench was formed and the verdict came into 4:1 proportion voting. Only Justice Krishna Iyer held a dissenting opinion. Number 2. Sanjeev Coke Manufacturing Company versus Bharat Cooking Coal Case 1983. Here, Supreme Court affirmed Justice Iyer's opinion. Means Supreme Court held the dissenting opinion of Justice Iyer. Number 3. Mafatlal Industries Limited versus Union of India case 1996. Here, Supreme Court reaffirmed the interpretation offered by Justice Krishna Iyer and Sanjeev Coke and Bharat Cooking Coal case 1983. Supreme Court also cleared that material resources means all physical resources and also movable and immovable property. So, it contains both public possessions and private properties as well. Again, Supreme Court also felt the need for 9 judges constitutional bench to interpret Article 39 subclause B. Here first, Supreme Court felt the need for a 9 judges bench to interpret Article 39 subclause B. Number 4. Mumbai based Property Owner Association case 2002. Petition filed in 1997 again against MHADA 1986, Maharashtra Housing and Area Development Authority Act 1986, where Chapter 8 got challenged, which contained allowing taking over property based on Article 39 subclause B mandate. This case was heard in February 2002 by a 7 judges bench of Supreme Court. Supreme Court again referred interpretation to a 9 judges bench of Supreme Court to interpret Article 39 subclause B. So here again Supreme Court felt the need to interpret Article 39 subclause B by a 9 judges bench. Now, the present legal face-off. After constituting a 9 judges bench by Supreme Court by Chief Justice of India D.Y. Chandrachud, Justice D.Y. Chandrachud goes to interpret Article 39 subclause B as by balancing between socialistic and individualistic view in Indian context. To explain why Article 39 subclause B needs to be interpreted by a 9 judges bench, he said a 5 judge bench in Sanjeev Kok in 1983 relied on Justice Iyer's view, ignoring that it was a minority view. And in Mafatlal case 1996, Supreme Court expressed its difficulty to accept the broad view of Article 39 subclause B and felt the need to form a 9 judges bench, which reverberated in Mumbai property owner case 2002. As there is no 2002. He concluded by saying, without diluting the constitutional social significance, we should not interpret Article 39 subclause B in a wider sense, that there is no protection to private right is left. Then he questioned, then how the private investment will come to India? Then Solicitor General Tushar Mehta, appearing for Maharashtra State, addressed to Supreme Court bench to give the extreme effect to Article 39 subclause B should be counterproductive and will not be in national interest. He quoted land selling laws to remove intermediaries, jamindars, was on another context and added Article 39 subclause B should not be read as there is no protection for private rights left. Meanwhile, Rahul Gandhi is asking to conduct a caste census to take an assignment to distribute wealth of India, jobs and other welfare schemes to scheduled caste, scheduled tribes and minority sections only based on their population and financial status added fuel to this fire, which also addressed by Directive Principle of State Policy Article 39 subclause B provisions and countered by both Prime Minister Modi and Solicitor General Tushar Mehta, mentioning Congress is trying to taking away the private wealth of Indian citizens. This is the summary of legal face-offs under which Article 39 subclause B is going through and ultimately keeping its legal validation alive. Thank you. Now today's question for you, that by which article Supreme Court is empowered to be the highest interpreter of Indian Constitution? Make your response as comment section. Thank you for watching the video. Like, comment and subscribe. Thank you. We will see on the next video.